Bible. Get it today. Good morning all. It's 29 minutes past 9. We are ready to start the day's proceedings. Please make sure that your cell phones are either off or on silent so that they don't disturb the proceedings. Thanks.
Tell him I'm here.
Now you confuse me. Good morning, Ms. Selina.
Apologies. As I've previously indicated, Chair, I'm a creature of instruction, so when I'm instructed to move, I move.
Oh, and good morning, Ms. Maya.
Good morning, Chair.
Thank you. And I don't know whether to say advocate. You say you were appointed as an advocate upon joining IDEC, I think you say in your statement. But with regard to admission, I saw no admission other than your admission as an attorney. So it may be a technical issue, but it exercised my mind. So I don't know whether to refer to you as Advocate Ramsamy if you are never admitted as an advocate.
Morning, Chair.
Good morning.
Chair, I'm an admitted attorney.
Yes.
State advocate is the title that is given to a prosecutor upon promotion. So.
We received the statement, I think, in the evening yesterday, I think.
Yes, Chair. Perhaps before you make any remarks regarding the statement, may I address the commissioners?
Yes.
Because I have got a request to make.
Yes.
As the commissioners are well aware, as we were leading the evidence of Advocate Johnson, some of my colleagues were attending to other matters, including this particular witness.
Yes.
Now, the administration hasn't quite caught up, I think, with us.
Yes.
So even the witness doesn't have a statement, so we can't start. I was going to ask for a stand down to allow copies to be made, and at least avail to the witness to enable the proceedings to start.
I thought the one we got was the electronic version. Aren't we able to start perhaps using that electronic version so that we try to save time?
It's clarified for me, Chair.
I'm actually being shown a hard copy in front of me.
Yes. Though the witness may have an electronic version of her own statement,
yes,
she has got significant annexures, and it's the production of those files that seems to have been delayed.
Yes.
Advocate Sigels Ngube would, if she had her way, her preference would be to start with the annexures immediately available for the witness, but we are not currently in that position. I'm not in a position to indicate how long a stand down would be required.
All right, then we'll stand down. But let me. That's your preference. Good morning, Ms. Sigels. Is that your preference?
Yes, Chair. That is the preference, and
all
the
right.
witness's preference as well.
Oh, all right, all right. Let me raise the point or the issue I wanted to raise.
Yes.
Having gone through the electronic version of the statement, which, as I say, we received in the evening yesterday, I noticed, and this must be true of my colleagues as well, that the statement implicates Advocate Johnson quite seriously. What I wanted to raise, I do have thoughts of my own as to why what I'm going to raise did not happen. My mind is focusing, for example, on the fact that what Advocate Johnson is implicated on was not put to her. I can imagine why not, but I would like you to please comment on that, Ms. Siegels, and Ms. Siegels Ncube, and perhaps also address us on how, in practical terms, this is going to be addressed so as to treat Advocate Johnson fairly.
Thank you, Chair. Chair, the position is that on the 22nd of July, when Advocate Johnson gave evidence regarding certain events that occurred in the Mokwele investigation, she mentioned the name of Mrs. Ramsamy. And during that evidence, I received personally, because I was assisting Advocate Selo, I received a message from a DPCI officer who had indicated to me that Ms. Ramsamy had made certain disclosures to him regarding these matters and had wanted to consult on the matters. That is why I excused myself from those proceedings and discussed it with the NPA, and we arranged a consultation with Ms. Ramsamy for the 22nd of July while Advocate Johnson was giving her evidence. So we first became aware of these allegations against her during her evidence, and the witness was very clear that she had wanted to give evidence in public. She was aware of the allegations that she was making, that they were serious, but had not wanted them to be put to Advocate Johnson until she had been given an opportunity to give her full version, because her intention was in any event to only make this disclosure under protected disclosure protection after Advocate Johnson gave her evidence. But given that Advocate Johnson had implicated her in these proceedings, she thought that the correct process to follow would be to come to us with that evidence. So we did not have this information prior to Advocate Johnson giving her evidence. It only became known to us during her evidence. The intention is to serve a Rule 3 notice on Advocate Johnson to address these allegations, Chair. And that will be done during the course of today and tomorrow, depending on whether there are further matters that emanate from her evidence. As Chair would notice from her statement, she wants to give evidence in two parts, and she's only submitted one statement thus far. There will be another statement which further implicates Advocate Johnson. So it is either that we'll serve the notice today in respect of this first statement, or we will wait until she concludes her evidence on both statements. Second statement not yet provided and concluded, and then we will furnish a full Rule 3 notice on Advocate Johnson.
And the first statement was finalized only yesterday.
The first statement
which was Advocate Johnson's last day of testimony.
Correct, Chair. This last night is when the statement was finalized at shortly after 6. And it was signed, she signed it this morning. The statement.
Oh, I did not even notice that what I read was not signed.
Yes, Chair.
Yes,
it was an unsigned version yesterday, and she signed this morning.
Oh, thank you, thank you. We'll take the adjournment then, and we'll hear from you when we should come back. Thank you.
Thank you, Chair.
Thank you, Chair.
So that, and then if we can just finish off with the report, you then have 6 instructions to investigators. So this is going to, is it primarily addressed to the investigators, or is it primarily addressed to Advocate Johnson and the investigators are copied in? How do you?
Advocate Johnson had not asked for this report. No one had asked me for this report. I, upon receiving the dockets, felt compelled to do this report because of my gut instinct and whatever happened on the 6th. And then when I received the dockets itself, it needed to be reported in a manner that we as prosecutors would report dockets. When you give an evidence report, it's generally to a senior to make a decision because you're not finding what you're supposed to, or they think you're supposed to be finding, or what the SAPS thinks you're supposed to be finding, or the complainant thinks you're supposed to be finding. So, but my instructions to the investigators were based on my unease and the lack of substantiation in the docket itself.
Okay, can you just take us through your instructions to the investigators?
Instructions to investigators. F. Adams is to be consulted. Full and detailed draft affidavits to be obtained before prosecution plan can be discussed. One of the 2 prosecutors must be present when this consultation takes place. You will also note that I'm trying to now involve the DD that is allocated on paper, because I'm working on my own under the I'm going to do the supervision of Advocate Johnson. So by saying that, I'm saying one of us, either the DD or myself, need to be present when this consultation takes place.
Okay, continue.
All information, documentation, and witness names, etc., to be contained in the affidavit draft from F. Adams.
So you want the evidence?
Correct. He's saying that he has proof. He's saying that someone slotted things under his door. He's opening dockets, but he only makes vague allegations and then pops up a name here and there, and then you don't know what's happening exactly. So I wanted a full and detailed draft report or affidavit from him. And he must advise us, okay, this is a witness that I know will come forward, or this is a possible witness, and this is the evidence that I have.
Can I just ask you before you continue, why didn't you at this stage say to Advocate Johnson that section 2813 that you had asked me to apply for, to do the application for on the 5th, I've now looked at the docket. I was uneasy before then, I'm even more so now, because in fact, the evidence that he says is contained in these dockets, it's not there. I don't see anything. So I don't think we should continue with the 2813.
That was one of the reasons I did the report. And the WhatsApps will show that I request that I send it to her before I send it to the rest of the team. My intention was to discuss it with her and to discuss my concerns on that day. However, the preceding messages that will be shown to the commission will then illustrate why that conversation never took place. It did, however, take place later on.
Bible. Download now.
My concerns.
Later.
The conversation between myself and Advocate Johnson did take place in January about my concerns.
Okay. And then just before I think you should finalize or finish off with the instructions, and then we'll go back to what you say in this report and then what was in the 2813.
Prosecutors to be informed before any interview consultation to take place with any person relating to this matter. May I explain why I put this in? there was so much speed and so much of need to get going where the prosecutor is not even ready to say, let's set down a plan of action. How are we going to ring fence? What? And Mr. Perumal was on this whole mission of, we need to do this, we need to do that, we need to contact this person, we need 28s for this, we need 28s for that, we need the files for the vetting. But I'm saying there's no substance. I don't have anything to even draft a prosecution plan. So my instruction is very clear. Nothing is to be done without my knowledge.
Would a prosecution plan proceed ordinarily? Would a prosecution plan precede the kind of activity that you say Mr. Perumal was involved with, demanding or requiring
Correct.
this and that, statements being taken, that would be led by the prosecution plan?
Correct.
Okay, and number 4?
Number 4 is no section 28 is to be issued or served without the prosecutor perusing same and then submitting to the head of office for signature.
What do you mean by section 28?
Section 28, 6 or 7, for information or for persons to be consulted with or
Summoned.
interviewed or summons to be interviewed, or for any documentation books or anything listed in section 28, 6 and 7 to be done.
And why did you put that in?
Because of the way Mr. Perumal was insisting this. It was brief conversations that he would phone me and say, hey, we need to do this, or hey, we need to start moving with this matter. I was also going on leave. So, and I'm going to repeat it, and I know it's going to sound like I'm repeating it ad nauseum, but my gut was not feeling comfortable compared to the 27 I had done in 2023 versus this.
And at that stage, there's no evidence, so...
There's nothing, there's no evidence. What do you 28 if there's no evidence? What evidence are you? Are you going on a fishing expedition?
Okay, and then you say, please note that there are 5 CAS numbers allocated. Once draft is obtained, the team can discuss the way forward. This is the draft affidavit. Now, can I just understand why you were asking for a draft affidavit? Because you have the section 27. What is the status of the section 27 as in the investigation? In the 2813 investigation, what do you call the section 27 referral affidavit?
My understanding is that the 27 is supposed to be your A1.
It's supposed to be your A1.
A1.
Okay.
It's a complaint received. But that's my understanding. It's not implemented within IDAC. My understanding is if you are filing an affidavit with allegations, that is your A1. That is your complainant statement.
Can it be supplemented?
Yes, it should be supplemented if needs be. But it cannot be a standalone affidavit and from there investigations flow in a different direction. Or not different direction, but investigations flow where we're taking now new A1s. But I was told that this was told to me in 2023. I was shut down with this. When I was dealing with that specific 27 in 2023, I held the same view, that the referral affidavit needs to be the A1 in the dockets. I was told that's incorrect and it's not going to happen that way.
So once the investigation has been authorized under 2813, was the process then that you have to then obtain a new affidavit?
No, with the 2023, I'm just going to refer to it as the 2023 referral. That complainant had come with a letter and a statement, an uncommissioned statement. When the matter progressed before myself and the other prosecutor got involved, the legal representative of that referrer submitted a very extensive formal affidavit, and that is in the docket. So we received two different, how do I explain it? So it would have been like this. We had the first where she initially, it was just a statement that she signed, and then we had the affidavit referral in 2023.
Okay, but that I suppose is different because in this instance with Mr. Adams, you have an affidavit. The section requires that it be either affidavit or it be a declaration. So in this instance, you do have the affidavit from him, but in your docket report, you're saying we must get a draft affidavit from him.
But a draft supplementary.
Oh, okay, so what you're intending is that it must be a separate. Okay.
Because also, you must also remember now, I'm in possession of original dockets, where A1's already existing. So you can never have an A1 and then take another A1 and then take a supplementary. It's an A1 and a supplementary, or an A2 and a supplementary.
Okay, and the purpose of this affidavit that you were saying now needs to, because you say if Adams to be consulted, full and detailed draft affidavit to be obtained, you put a draft in bold, and what is the purpose of that? So you're not wanting a complete document from him. You as the prosecutorial team with the investigators want to sit with him and take a statement from him. And that is now part of the preparatory investigation,
Correct.
which is the 2813.
Correct.
Is that how the process works and is supposed to work?
Which process?
The process,
No, it's not supposed to be like that, but it's generally in IDAC space at the moment that people or prosecutors get draft affidavits. When most prosecutors prefer the draft only if the investigating officer is suggesting that this person is a 204. Then it would be a draft. But we generally, because we're prosecution-led, if the investigator says he needs to consult with you and he goes to you, I will constantly be updated about what is in the draft. They'll either send me WhatsApp pictures, they'll email me the draft, I'll read, I'll say, okay, but this witness is indicating that Mr. X has in his possession emails. Has it been canvassed? Or it would be, the deponent is saying, in 2024, I was in Limpopo and, whereas we have proof that he was in fact in Dubai. And I would then ask, has this been canvassed? Why is he saying this?
so you are, when this affidavit is being prepared for Mr. Adams, you're trying to gather evidence.
Correct.
To see whether there is a case, a prima facie case, but you also in that process preparing an affidavit for him as the prosecutors.
It's supposed to be that way, yes,
Okay.
because of the prosecution-led guidelines.
And assume that if you meet with him and he gives you all the documents and you're now convinced that, well, there is a case here, you then assist him in preparing that statement for him as the prosecutors.
I wouldn't assist, I would be present.
Okay.
The reason I'd be present is that I would be able to assist the investigating officers and the witness with regards to the structuring of the affidavit.
Which is what happens later on
Later
in
on.
January
The
with
prosecutor
supplementaries.
is not allowed to become a witness in their own matter.
Yes, that is what I was trying to understand. So when you give the instruction to the investigators, you're removing yourself as being potentially a witness, but you're still consulting with the witness when that statement is being prepared or being taken.
Yeah.
It's just that it's the investigator that's doing the drafting and that. Okay.
Can I put it to you in a different way, in an easier way? Because of Section 28, prosecutors are allowed to consult with witnesses, right? my previous DD, who has retired, deputy director, he always said to me, because he comes from DSO, never consult with the witness where you don't have a statement, at least a draft, because you're walking in blind and you are going to be a witness. So if you're going to consult with the witness, ensure that you have a draft in front of you. You know what you're going to question and how you're going to assist the investigators. So that is what I was trying to say.
Okay. So as part of that process, you say that the Adams is consulted, and then one of the two prosecutors to be present when that consultation takes place. So you want the draft statement before you plan your before you prepare your prosecutorial plan.
If there's ever going to be a plan, because my thinking was when we go for these supplementaries, because now we've got dockets, and we're instructed to investigate these dockets. When we go for the supplementaries, obviously he's now saying, and he's publicly said it, I've got documents, they were slotted under my door. Obviously in those documents, it might...
In the A1s of the docket. Substantiate what was contained in the A1s of the dockets,
yes.
Not the Section 27 affidavit that we've seen. Or
Some
what?
of, no, not the one that you've seen, no.
Okay.
But because, am I allowed to speak about the forklift?
The forklift.
Yes, no, yeah.
One of the issues that I picked up here of the one that was flighted is there's no mention of a forklift at all. But Mr. Rapeso will confirm that we received, we just had to trace it, Langlagte docket for a forklift, and it was in the 27 referral. And the supplementaries that we took was one of them for the forklift. And the first 3 witnesses that were identified were from the forklift documents.
Okay, your point being that if there wasn't mention of the forklift, why were you going down that rabbit hole of investigating the
And there is
forklift?
it was multiple consultations.
Can I just ask relating to this? What is there a guideline or what informs what goes into this draft affidavit that you're getting? And it's related to what you've just spoken to now, which is you have a Section 27 affidavit. And then you get the one that was flighted here, I want to use it as an example. And then you get the Mr. Rapesu supplementary affidavit that speaks about the PKTT, when the Section 27 that supposedly is the basis for the investigation says nothing about the PKTT. On the face of it, it looks like Mr. Rapesu would have sat down and suggested to the witness that you're not saying anything about the PKTT, let's talk about the PKTT, without it being found, I'm saying on the face of it, without it being founded on the Section 27. And I guess my question is, what is there that avoids suggesting things to witnesses or in a statement to avoid and to prevent, in fact, investigators imposing what they really would like to be in a statement which the witness may not have been interested in, but as seems to have happened in your cases that we are concerned about, that investigators had their own stories that they wanted to tell and that they wanted to be investigated, and they went to a witness and said, give me something that deals with this.
Generally, I would assume it's ethics and morals that would guide someone not to do that. As we can see, it's not done that way. But generally, certain investigators and certain prosecutors don't work in isolation. I personally, since the 1st of March 2023, have never gone to a consultation without at least 2 investigating officers or another prosecutor and myself. It's the safety net. So in some groups they do, and some groups they don't, but with the team that I worked with, it was never a prosecutor or an investigator going on his own. But I will qualify that with the fact that you must also know that if you have 2 investigators that have the same agenda going to that witness, which is one of the complaints that I do make to Advocate Johnson, and it is in an email, where prosecutors and other investigators were being excluded, and things were being done in a certain way, and statements were taken in such a manner that it doesn't even give you an offense.
I guess what I'm asking is, and it's part of a debate that was had with Ms. Johnson, about what Section 2813 permits to be done, because you look at a referral, it doesn't speak to anything that you now find in an affidavit. And I think her answer about those kind of concerns, and I paraphrase how it would have been raised with her. Her answer would have been along the lines that, well, when we investigate and the stuff comes up, it may not have been in the Section 27, which is silent about a particular topic. But when we now, as we do investigations under 2813, then we end up, finding this stuff, and that becomes justification for why, you have matter that looks like you went outside the parameters of your affidavit.
If I may give a practical example of, remember I did the 27 in July. So between 1st of March and April, I was given what we call alphabet soup. So we've attached acronyms because the companies or whatever, just to shorten it, that we were investigating. And I think it was towards the end of March, I had discovered that there's a link from a project that is already authorized to another docket that is within the DPCI space. It is also investigated by the DPCI that has been seconded to IDAC, but the link and the suspects are glaring. And I approached the project manager as to what do we do now, because some of the accused or identified suspects are on the 28 that's already authorized, some are not, and the scope in which are the parameter, the legislation, that some of the legislation that's applicable to that offense is not covered in the initial 28. She said to me that we would have to do a new 28. So I said, no, but why? Why would we need to, why can't we do an addendum? Because an addendum is contractually binding, and it would make sense because we discovered it during the course of. And so there was a meeting that was set up with Advocate Johnson, and we asked her, should we do another new 28? So then I asked, but can't I do an addendum? And she said it was fine. The addendum was drafted, it was attached and filed to the original 28. And that is the process we followed with 3 other of my matters.
So that addendum would be a foundation and an explanation how you end up with these new other people that were not in the original. Thank you.
But in this instance, if the Section 27 affidavit that you saw didn't have the allegations contained that you see in some of the A1s in the dockets, what do you do if the decision is that, well, even though it's not in the Section 27 affidavit, because it's in the dockets that have been referred, we should still investigate it? What would the process then be?
I would have still asked to do an addendum, but because in my 2813 and and I'm standing by it, the original 27 had PKTT and slush fund and polygraph. That 2813 stood. However, my concerns were about what substantiated it. We know you've got resources. I've got interlocutories, I've got high court applications, I've got trial matters to be attended to, and I'm dealing with something that doesn't have substantiation.
And in your 2813, you don't mention the PKTT.
I was told specifically not to mention PKTT.
Was that in the, okay, so let's just step back. So you do the 2813 on the 6th. At that stage already, you didn't mention PKTT. Was that a specific instruction, or was it to keep the 2813 vague?
It was to keep the I was, in the 2813, I was not allowed to mention detail. I was told, keep it vague.
Okay, so even though, okay, that makes more sense. I just wanted to confirm that it wasn't, as you said earlier, a specific instruction not to mention the PKTT. It was not the detail of the allegations in the 27. It's like how you would just say this is what there was.
If I may explain why I understood what keep it vague meant.
Can you do it with reference to the actual 2813? Maybe we should do that on page 107. Because you don't mention any names or specific. So at 1.2, for example, you say the office received a complaint in terms of 27 in November. 1.3, allegations leveled against senior members of SAPS, allegations regarding the appointments of various high-profile officials, unlawful actions regarding the vetting and polygraph testing perpetuated by officials of crime intelligence. But in you saying the Section 27 that you saw, names were mentioned.
Correct.
But not all the names that you were given by Advocate Johnson to be suspects.
Standard Bank, Stanbic Bank. Get it today.
The names of the individuals in that investigation were so high-ranking and so the names of the individuals in that investigation were so high-ranking and so high-ranking, let's keep it at that, that we kept our documents vague. Even our reports and all of that, until the investigation was completed, we would hand-deliver progress reports. Information leaks.
Okay, so I can understand that, because when we looked at the, which Commissioner Baloy mentioned, the consideration of mandate document, for example, doesn't really give you any detail. It's very scant. So I can understand that you would want to keep that vague, right? The 2813. But here we're talking about, so there's a mention about the PKTT. Where would one then find in your vague 2813? Where do we slot PKTT in between 1.3 to 1.7?
Fraud and corruption pertaining to awarding of tenders and/or contracts within SAPs and/or circumventing of procurement processes. Because remember, it's the purchase of the properties, it's the forklift, and it's the use of the SSA fund for laundry and those things.
Okay. And the 20, this wasn't your, I mean, you've done a 2813 before in respect of the previous 27 referral, but have you only done two 2813s or you before
No,
this?
I've done multiple 2813s.
Okay.
Most of them are as vague as this.
Okay, and that's intentional, or is it always on a case-by-case basis that she gives that the instruction is given to keep it vague?
This time she said keep it vague, and I'm assuming that she understood, or she knew that I would understand because of the other matter. But our 2813s are not, we don't, we work, so we're different units, right? We've got the ESCOM, the Transnet, I work in security cluster unit. It's the Zondo recommendations for the security cluster.
Yes.
It is high-ranking crime intelligence, high-ranking SAPs, high-ranking political individuals that were alleged to have fleeted money from SAPs and SSA. So we generally keep it vague like this.
Okay. Then can we, are you covered? Okay.
Thank you.
We can go then to the email. I think it's first the WhatsApp message that you send to Advocate Johnson on page 161 of, we'll first deal with the WhatsApp, which is on 116 of file 10.
Are we going to flag the whole?
We are just going to deal with the Good Morning Advocate Johnson. I have prepared the summary and preliminary instructions for the team. May I email them to you for your guidance before sending to the team? That's at 10:50 on the 10th.
Yeah.
And she says, yes, please.
Correct.
Which you then do, if we go to, still in that same file, we go to page 161, the bottom of 161 at 10:57.
Good day, Advocate. IDAC docket summary. Good day, Advocate Johnson, for your perusal and guidance.
Okay, and she does, Advocate Johnson then later responds to that, but can we just deal with, at that stage, I think there's an acknowledgement if we go to 167 of the document, file 10. At the middle of the page 166, my apologies.
From Advocate Johnson, Tuesday, 10 December 2024, 11:05, to Drishanta Ramsamy Dylan Perumal. RE, IDAC docket summary. Drew, noted, thank you. Please run this by Chief. He had interviewed the complainant. It would help if he was able to peruse the document and then indicate if he thinks the complainant will have access to the details we require.
And that is in response to what is set out in your docket summary, because your email to Advocate Johnson just says for your perusal and guidance.
Correct.
So she's responding to what is contained in the docket summary.
Correct.
To say you must run this by the chief. So what is it that you're running by him? The requirement to get or the instruction to get the draft affidavit and the documentation, I'm assuming?
It would be the documentation, because I remember having a conversation.
I think we get to that later. Where
Yeah.
he responds, yes. But that's later in the day, because there was a lot going on the
There was
10th.
a lot going on, but he indicated that, yes, they have seen the documents that is in Fadil or Mr. Adams' possession. And a lot of my concerns will be calmed.
Okay, then I think we have at back to the WhatsApp from Advocate Johnson at page 116, file 10. Know that she acknowledged your summary report, and then that was in the email at 11:05. You don't really have any discussions with her during that day. She sends you an WhatsApp 1603, which starts with the one just below, yes, please. You can read that and then take us from there.
Drew, speak to Chief. I need you guys to urgently subpoena Lushaba's bank accounts before they move money. From the date he was acting as DivCom to date.
Okay, let's just pause there. So at this stage, we know that you've sent the